Okay, hello everyone. It's time for the webinar. My name is Emmett Carlton. I am Deputy Chief of the Office of Intergovernmental Affairs in the FCC's Consumer and Governmental Affairs Bureau. The office is also referred to as IGA for short. IGA acts as the liaison to the state and local governments. So please feel free to reach out to us if you need anything. You can reach out to us today during the webinar or anytime by using our email account, which is iga@fcc.gov. Again, that is iga@fcc.gov. So please, during the webinar, send us your questions to iga@fcc.gov. And without further ado, our first speaker is Adam, and I hand it off to you.
Thank you, Emmett, and good afternoon, everyone. It's a pleasure to be with you on this webinar today. My name is Adam Copeland. I'm an Assistant Division Chief in the Wireline Competition Bureau in WCB's Competition Policy Division. And I'm joined here today by my colleague, Terry Natoli, who I'll let introduce herself briefly.
Hi, I'm happy to be here as well, and I'm the Deputy Chief of the Competition Policy Division, and Adam and I work very closely on this item together.
So Terry and I are here to discuss the wireline infrastructure related document, which as Terry referred to before, we call an item here at the FCC, that the Commission adopted on April 20th, 2017. And again, as Emmett said, we encourage any questions that you might have during our presentation. Just please email them to iga@fcc.gov. So the wireline infrastructure item, which is entitled Accelerating Wireline Broadband Deployment by Removing Barriers to Wireline Infrastructure Investment, explores a number of ways to accelerate the deployment of next-generation wireline networks and services by removing barriers to infrastructure investment and streamlining the regulatory processes associated with transitioning to these more modern, innovative networks and services. As a general matter, the item proposes or seeks comment on a number of actions designed to accelerate: 1, the deployment of next-generation networks and services by removing barriers to infrastructure investment at the federal, state, and local level; 2, the transition from legacy copper networks and services to next-generation networks and services; and 3, the elimination of Commission regulation that increase costs and slow broadband deployment. More specifically, the item contains 3 parts: a Notice of Proposed Rulemaking, or NPRM, a Notice of Inquiry, or NOI, and a Request for Comment. At a very high level, the Notice of Proposed Rulemaking proposes rules related to 1, pole attachment reforms, 2, the copper retirement process, and 3, the Section 214A discontinuance process. The NOI asks questions and seeks comment on using authority granted to the Commission under Section 253 of the Communications Act to preempt state and local laws inhibiting broadband deployment, and also preemption of state laws governing copper retirement. And then finally, the request for comment seeks comment on revisiting a previous declaratory ruling which expanded the interpretation of what constitutes a service for purposes of the Section 214A discontinuance process. So turning first to the pole attachment reforms in the NPRM. So Section 224 of the Communications Act grants the Commission the authority to regulate the rates, terms, and conditions for access to poles, ducts, conduits, and rights-of-way that are owned by telecommunications carriers and electric, gas, water, or other public utilities. So when we refer to pole attachments, we're actually referring to not just the access to poles, but also to ducts, conduits, and other rights-of-ways that are controlled or owned by utilities and telecommunications carriers. Section 224 is somewhat unusual in that it allows states to assert their jurisdiction over the FCC's federal jurisdiction. And to date, 20 states and the District of Columbia have exercised that right and established their own legal regimes governing pole attachments. So the reforms that we're going to be discussing today and that are proposed or that we're seeking comment on in the item only apply to the federal regimes. In the 20 states in DC where the federal regime has been reverse preempted, these would not have any legal effect if they are adopted by the Commission. The NPRM that was adopted in April proposes to reform the FCC's current pole attachment rules to make it easier, faster, and less costly to access poles, ducts, conduits, and rights-of-way. First, it proposes to shorten the Commission's existing pole attachment timeline, and it seeks comment on alternatives to the Commission's current pole attachment process. This could reduce the average process from 150 days, or 5 months, to 30 to 60 days. The Commission also seeks comment and proposes changes to reduce make-ready charges paid by attachers to utilities. And by make-ready, what the item is referring to are modifications of poles or lines or installation of certain equipment to accommodate additional facilities. Other proposed changes would ensure that pole attachers are not charged multiple times for capital costs by codifying the elimination of certain capital costs from the pole attachment rate formulas. Also, we seek comment about adopting a formula for computing the maximum pole attachment rate that may be imposed on an incumbent local exchange carrier, or ILEC. The item also seeks comment about establishing a 180-day shot clock for Commission consideration of pole attachment complaints, and also seeks comment on adoption of rules that would allow incumbent local exchange carriers to gain non-discriminatory access to poles owned by other local exchange carriers pursuant to Section 251 of the Communications Act. In addition, the NPRM seeks public comment on types of pole attachment data resources that are currently available to make more information publicly available regarding rates, location, and availability of poles for faster pole attachment timelines. Section 224 does not apply to poles that are owned by railways, electric cooperatives, or states and localities. So the NPRM seeks comment on actions that the Commission might be able to undertake to speed the deployment of next generation networks by facilitating access to infrastructure that is owned by entities that are not subject to Section 224. So that is the extent of the pole attachment matters for the NPRM. It covers a very wide range of issues. And so before I turn it over to Terry to speak about copper retirement and Section 214 discontinuances, I just wanted to see if we had any questions that had come in about pole attachments. Okay. So Terry will take it over for now, and if there are pole attachment questions that come in, we can always return and talk about those later.
So the second major part of the notice of proposed rulemaking deals with issues that you are all most familiar with in terms of the technology transition related issues. They deal with both notice and discontinuance of services and facilities that are resulting from the change from the existing legacy copper networks that were traditionally the networks underlying the legacy services to most primarily the new fiber-based networks. So we break the NPRM down into two different sections in that regard. The first deals with seeking comments on ways to reduce the regulatory burdens of retiring legacy copper facilities and other notice of network changes that are part of that process. This section of the Act that governs these types of rules, Section 251C5, is a section of the Act that contemplates a notice-only process, not an approval process for retiring facilities. The second section of the tech transition issues deals with the Section 214 discontinuance process and how that process, which does require approvals, application and approvals, is tied up with retiring and eliminating services that relied on the legacy copper networks. And our item asks for particular comments with respect to that process in general. So now getting down to the more specific details of what we're seeking comment on with respect to each of these two sections. Under our section on considering copper retirement reforms, we're seeking ways that generally will reduce the regulatory burdens on the entities that are retiring their legacy copper facilities, but to do so in a way that still complies with the Act's requirements for the appropriate level of notice that is necessary. So over the last couple of years, there have been a number of changes made to the copper retirement process, most specifically since 2015. And this notice is seeking comment on whether those changes have really been helpful or whether we should actually go back to the prior copper retirement rules that occurred prior to 2015. In an alternative to that is to retain some of the 2015 changes that were made to the copper retirement process. Ones, for example, that expanded the definition of what it actually means to retire copper, or expanded the groups of recipients that were required to receive direct notice of the copper retirement, or whether we should just entirely eliminate the distinction between the copper retirement process and other network change notification processes that generally apply when an incumbent local exchange carrier makes changes to its network. And the important thing to keep in mind is that under the statutory provision for copper retirement network change notifications, that statutory provision contemplated that these notices really were to be provided to the other network providers that were interconnecting with these particular networks that are now being changed, so that those other interconnecting providers can then make whatever necessary changes they need to make to their networks to continue to provide their services over those networks. Additionally, we're looking at ways that we can reduce the waiting period for a copper retirement notices, that we might be able to eliminate the direct notice requirement to retail customers of copper retirements, and other types of changes that may not be necessary to ensure that the consumer still has whatever information it needs in the event that a copper retirement is occurring, but that it is effectively not changing in any way the actual service that those customers are receiving over their copper networks that are now being converted to fiber. In addition, we're taking this opportunity to ask questions about whether there are changes to our more general network change notification rules that could be made, those that apply to network changes other than copper retirements, which have always been treated under the Commission's rules differently than other network changes. We see comment specifically on eliminating a prohibition that has existed since the 1997 rules that actually applied to network change notifications, so that the providers that are making these changes to the networks are able to more freely discuss these plan changes with entities that are either affected, that may be relied upon, with state or local governments, with anyone that may benefit from being able to know in advance what the incumbent LEC is thinking about doing with respect to its network. And it would enable the incumbent LEC in some cases to actually get information and factor it into their planning process in advance of actually making the public notice of its change. So we're especially seeking comments on that area, and whether this would be a more, it's better to have more information out there at the earliest possible time. And we also see comments on eliminating the requirements that carriers notify customers when network changes are going to occur with respect to certain types of terminal equipment that is legacy equipment that may no longer be supported or able to even be purchased in stores, and whether there are other ways that this terminal equipment, these changes to this equipment can be made available to consumers. Before I move on to the proposed changes to the Section 214 process, we wanted to know whether there were any questions that anyone may have with respect to the copper retirement and network change sections of the item.
It looks like we do have one question that's more general in nature. Bruce Regal asks, is the Commission concerned that in acknowledging the advisability of holding this webinar to assist state and local governments in preparing comments in this proceeding, but holding the webinar just hours before comments are due, the Commission may be undermining the validity of any decisions it may make in the proceeding? So thank you for the question, Bruce. It is correct that comments are due in this proceeding tomorrow, but I think we'd want to emphasize a few things. First of all, reply comments are not due until July 17th. So just because the comment deadline is tomorrow does not mean in any way that the record is closing. And then even after the reply comment deadline takes place on July 17th, the record still does not close. It is still permissible. This is a proceeding where ex parte presentations are permitted after the close of the comment deadline. So if there are issues that come up in the record, you are always free to submit ex parte presentations or documents into the record after the close of the comment cycle. And we genuinely want to hear from state and local governments to help inform the decisions that we are making. So again, the comment deadline is tomorrow, and we recognize that folks who are turning to these issues maybe for the first time this week or looking at this for the first time today may not have time to submit comments. Please do submit a reply comment if you can do so before July 17th. But again, we welcome input from parties after the 17th as well.
And just to add to what Adam said, with respect to ex parte filings, the initial ex parte doesn't have to be in writing. You are free to set up meetings with us. We're happy to do telephonic meetings. We do that all the time. We recognize that it's not always possible for particularly folks that are dispersed throughout the country or in other states to travel to Washington, D.C. so we can have teleconference comments and discuss them. And then, of course, they do have to be followed up with written ex parte. But we can't emphasize enough, tomorrow just starts effectively the public comment and input period, which we expect to go on for a few months.
Okay, so I think we're going to keep moving, but if there are specific questions or more general questions, remember the address is iga@fcc.gov.
All right, barring no other questions at the moment, let me move on to the Section 214 discontinuance section of the technology transitions subsection of the NPRM. So under this Section 214, as most of you may know, Section 214 is a section of the Act that requires service providers of telecommunications services to file an application to discontinue any service that is a telecom service when it is no longer going to be available to existing or future customers, or if something about that service is either impaired or adversely affected so that it is no longer available to consumers in the way that it was prior to whatever action happened or is about to happen that will impact the service. And so how it relates to the copper retirement and the transition from copper networks to fiber networks, as I explained previously, which is basically just an approval process, a notice process. The Section 214 application process is what a service provider actually needs to go through when a change to its underlying network, i.e. when its copper facilities are being converted to fiber facilities, and the underlying services that are being provided over those facilities are either discontinued, reduced, or impaired. And if that is the case, then that incumbent service provider or any telecom provider that's facing a similar change in its underlying network must indeed apply to the Commission, provide notice to all of its consumers, to the states, the local governments, the governor, the tribal entities, anyone impacted by this service. And there is a process for public comment and to actually hold up the discontinuance, if necessary, until the issues are resolved, that whoever might be affected has concerns about. So what we're doing in this section of the NPRM is asking questions about ways that we can streamline the process for services that appear as if there would be no adverse impact on particular end user customers. For example, we're proposing to streamline the discontinuance process for applications that what we call grandfather existing low-speed legacy services for the current customers that receive those services. And what we're proposing to do is, because they would not harm anyone that is receiving that service today, it would only be new customers that may seek to sign up for these services. And because they're low-speed legacy services, it's unlikely that there are new customers signing up for such services anyway, but we're seeking comment on that. We're looking at reducing the comment period to 10 days and an automatic grant period to 25 days for these services, which would essentially be those that would fall between below 1.54 megabits per second, lower than the current DS1 speeds. We're also looking at whether we can grant certain applications to grant low-speed legacy services without requiring any period of public comment. And those would be, for example, services where there are no customers on that taking that service at all, and there haven't been for a certain period of time. But we're seeking comment on whether that is a good idea or not, and what the time frames should be that the carrier would not have customers for these services, such that the Commission could be comfortable and sure that there would not be any potential consumers adversely affected. We are also seeking comment on how discontinued applications or discontinuance services could impact priority services that government users might rely on, and how it might uniquely impact government users who rely on the availability of certain services, and those services, how they operate with respect to certain equipment that the government users might have, and how that would fit in with their budgetary process and their ability to get new new equipment for services that rely on newer technology. We're also looking at streamlining the discontinuance process for applications that may have been grandfathered, for which we granted streamlined treatment, and a certain period of time has now passed such that those grandfathered customers were on notice that their service eventually would likely be discontinued, and whether a 6-month period is sufficient or whether there should be a longer period or perhaps even a shorter period. We're also asking about interpreting our section 214 requirements, that from what perspective should the service that's being discontinued, what is the perspective that service should be viewed, and whether it should be something that is viewed from the perspective of the carrier who is actually offering that service, or whether it should be the perspective of the community that is taking that service, whether it is how should that be viewed from the perspective of the rules when saying when a service is discontinued. And then finally, we're looking at a couple of other potential areas. What are sufficient substitute services that could be available generally throughout a community, such that a provider that is seeking to discontinue a service could rely on to show that it meets the comparable service standard under the 5 various things that the Commission looks at in considering a discontinuance authority. And then generally, even though those deal with all the notice of proposed rulemaking questions for the related to 214, we also, as Adam mentioned initially when he was first introducing this item generally, there's a separate section that has a request for comment that is also related to the section 214 process, and that deals with, sorry Adam, thank you, that deals with looking at a 2014 declaratory ruling that the Commission made, and a subsequent 2015 order on reconsideration that expanded basically what the definition of service was for purposes of 214, and we're seeking comment anew on that, and asking commenters to give us information on that particular issue, because it may have made it very difficult and created a bit of uncertainty for both the service provider and the community as to when a Section 214 application may be required. So are there any specific questions on the copper process or the 214 process, or anything that Adam has already discussed?
Okay. Remember, any questions, go to iga@fcc.gov. No. So moving on now to the notice of inquiry, which is a subject that we know is of great interest to state and local governments. So the notice of inquiry seeks comment on whether or not the Commission should enact rules pursuant to its authority under Section 253 of the Act. And generally, Section 253 of the Act addresses barriers to entry, and it gives the Commission the ability to preempt state and local regulations that prohibit or have the effect of prohibiting the ability of an entity to provide telecommunications service. The first part of the NOI seeks comment on using Section 253 preemption authority to enact prospective rules that would prohibit the enforcement of state and local laws that inhibit broadband deployment. And it's asked specific questions about a number of different areas and a number of different practices which may be going on at the local level. So it specifically asks questions about how the commission might address the following practices: deployment moratoria, delays in rights of way negotiations and approval processes, excessive fees and costs, unreasonable negotiating conditions, potential bad faith negotiation conduct in the context of permitting, construction, licensing, or granting access to rights of way. In asking these questions, the NOI recognizes that states and localities play a vital role in deployment and addressing the needs of their residents, and it seeks comment on actions that the Commission can take to work collaboratively with states and localities to remove barriers to broadband. It also seeks comment on how the FCC can best account for states and localities' important roles and the extent to which the Commission can rely upon collaborative processes to remove barriers to broadband deployment before resorting to preemption. The NOI recognizes also the important role of the BDAC, the Broadband Deployment Advisory Committee, which has both state and local representation, and the contributions that the BDAC will make in this inquiry process. In addition, the NOI seeks comment on whether the Commission should enact rules consistent with Section 253 of the Act to prohibit unreasonable conditions or requirements that might impede the retirement of copper facilities. More specifically, the item seeks comment on whether there are state laws governing the maintenance or retirement of copper facilities that serve as barriers to deploying next-generation technologies and services that the Commission might seek to preempt. So that is the end of our formal presentation. Again, comments are due tomorrow, and as we were saying before, as Terry rightly put it, in many ways that comment deadline is really the beginning of us receiving the public record. Reply comments are due July 17th, and we would certainly encourage folks to submit reply comments, but also to submit ex parte presentations. Please do get in contact with any of the four people here listed on this slide, Terry and myself. Michael Ray and Michelle Burlove are the official FCC contacts that are listed on the item. Feel free to get in touch with any of us with specific questions. Also feel free to get in touch with any of us to set up meetings, presentations. As Terry was saying, we will do those over the telephone if folks cannot travel to the Commission. We really are seeking to gain a full public record, which includes input from states and localities, and we realize that many, if not all of these issues that are teed up in this item address issues that are sensitive to states and localities, and we really want input from all interested parties. We are still accepting questions for the webinar, so feel free to email them to us at iga@fcc.gov. Yeah. So a question here, how are you guaranteeing that you only reduce or eliminate 214 notices if the technology is replaced with more modern technology? Just wondering if you're asking how to shut down the notice of disconnection process. We have seen an attempt to switch out copper and replace with wireless, and wireless can't be used by businesses to even process credit cards or folks to use the phone for heart pacer monitoring. So I'm gonna let Terry take that.
As I think we specifically stated, we're not in any way attempting to or even proposing to reduce or eliminate 214 discontinuance applications and notices to affected customers at all. I mean, the comments, the request for comments on the Section 214 side deal with streamlining the process once the public notice has been made and the notices to consumers have been provided. And the particular services that we are looking at streamlining our rules for are services for which the service provider will need to demonstrate that there is a replacement or comparable services available, I guess is the appropriate way to explain it. Comparable services are available either through that provider or within the community before they discontinue the service. And if there aren't, or a recipient of the notice believes they are not, then they have the opportunity to avail themselves of the objection period that is built into our process, and that the carrier is obligated and will continue to remain obligated to advise affected consumers and businesses of when they file their application to discontinue the service. I'm not exactly sure. The question says, wondering if we are asking how to shut down the notice of disconnection process. I think that
Probably notice of discontinuance.
if that means the discontinuance process, no, as I mentioned, where the proposals do not contemplate eliminating the Section 214 discontinuance application process at all. All it seeks to do is to, when an application is required under Section 214, to see if it makes sense for certain services to expedite that process if there are no entities or consumers affected, adversely affected. And I think the last part of the question, it seems to relate to the key issue in a lot of the technology transition related Section 214 discontinuance applications, where you're dealing with a change in the underlying technology from copper to something other than wireline. And that is something that is still part of the application process, where providers will still need to demonstrate that the service is capable of replacing the service that they are discontinuing. And if the consumer feels like it is not capable of it, they will have the opportunity to object, and the commission considers that objection the way it has historically considered the objection in whether or not to grant or to delay the discontinuance of that service.
We have another question here, and again, we're accepting questions. Terry and I can stick around for people to continue to submit questions at iga@fcc.gov. The question is, do backup power requirements count as, quote, changing in any way, end quote, the service consumers receive with respect to copper retirement?
So again, let me just clarify the difference between copper retirement, which is transitioning underlying copper facilities to fiber facilities, and then a separate and different process for discontinuing services that are provided over copper when the services themselves are affected by the change from copper to fiber. So first and foremost, backup power requirements, as you may or may not know, have been addressed by the commission in over the past several years, and are required to be provided of all service providers that provide voice and telecom services. So the backup the change in copper to fiber alone is not considered to be a change in the underlying service per se for discontinuance purposes, because backup power requirements are incorporated into a service provider's obligations to provide those services. So that alone does not generate a 214 application.
We have another question. Hang on one moment. Okay, so we have another question. The question reads, when the commission refers to quote unquote bad faith negotiation conduct, is it considering bad faith conduct only by state and local governments, or also bad faith conduct by providers? If the latter, what kind of potential bad faith conduct by providers does the commission have in mind? So the context for asking about bad faith negotiation conduct is in the section 253 part of the item, which is in the NOI, and that is referencing specifically conduct that is going on by states and localities. Section 253 only applies to laws and regulations that are adopted by states and localities. With respect to a telecommunications negotiation, there is not a statutory obligation for providers to adopt or to negotiate in any particular way. In the cable franchise context, there is a good faith negotiation requirement, but that does not apply in this particular context. But the context for asking about bad faith negotiation conduct is in the 253 context, which only applies to state and local governments. Okay. So there was also a question about, right. So we don't see any other questions in the queue. So please do again take advantage of the contact information that is up on your screen now. We're happy to speak with you offline and provide any answers about the item. Again, we greatly encourage you to make your voices heard in the record through filing of comments or reply comments or ex partes. And again, we are happy to talk to people in ex parte meetings, either here at the commission or over the telephone. So please get in touch with one of the people here who are listed on this slide to set up one of those meetings. And I think Emmett is going to wrap up the presentation. We actually do have one more question. So we have a substantive question. And if there's others, just send them now. So the question reads, is streamlining the section 214A discontinuance process, is the FCC seeking to establish a rebuttable presumption with regards to fiber-based services, referencing paragraph 95 of the NPRM. So give us a moment to look up paragraph 95 of the NPRM just so that we're on the same page.
I know we should have these all memorized, but right now we don't. So sorry about that. So yeah, that is a very general question that the commission is not seeking to establish a rebuttable presumption per se. I think that specific question is asking just generally, is there anything in the community that is readily available that is automatically deemed to be a comparable service based on the feedback and input that we would get from the public, and I guess in practice you may view it as a rebuttable presumption in the sense that with these 214 applications, as I said, you would still file, we would still contemplate a way of streamlining these 214 applications, but there still would be a comment period. And if there's a comment period, you could object to it, or you could claim why it wasn't, it didn't meet the test for being a comparable service. But that is going to exist for any of these potential streamlining processes. At least that's what is being contemplated in terms of from the perspective of the questions that we are asking right now. But we are seeking, I guess I can't stress it enough, comments from you all to know whether, if there are reasons why you feel like replacing copper networks with fiber networks do not automatically guarantee the availability of comparable services. Those are the types of comments we want to get in the record, and why.
So we have another question. And again, if you've got some last minute questions, we're happy to answer them. IGA@fcc.gov. This question reads, with regard to pole attachments, is the Commission engaging technology and solution providers to gain their input in architecting new engineering and attachment guidelines? Broadband time to market must be balanced with shared responsibility to ensure the safe and reliable operation of the grid. There are select technology partners working in this space to provide alternatives to traditional methods. So the questions that we ask in the pole attachment section are all prefaced with the idea that the Commission is very much aware that there are very important safety issues that tie into making attachments, both with respect to the people who are actually working on poles, and also with respect to issues like making sure that the electrical grid is not compromised in any way. The Commission is not, to my knowledge, independently engaging with technology and solution providers on these issues, but our public comment process is open to all entities. So if there are ideas that folks in the technology space believe we should be considering, we would highly encourage those entities to file comments, to get in touch with us, to let us know about solutions that we may not be aware of or that we may not have contemplated. One of the sections of the item does discuss the types of data resources that might be available so that providers can more easily access poles and more easily find out where poles are located. That is often not a digital process and is a very painstaking analog process with people scouting out where poles might actually be. And so we are seeking comment on the types of resources that might be available to potential attachers to facilitate the deployment of next generation networks. But if there are insights here that we have overlooked or that are not teed up directly, we do encourage folks to let us know what types of resources may be available to facilitate safe and speedy access to poles.
I just want to follow up just a little bit, just generally on some of the questions that have specifically raised detailed questions regarding the Section 214 discontinuance aspect of the proceeding. When there are differences when the Commission proposes something in an NPRM and when it just seeks comment generally in an NPRM. And with respect to most of the questions that were raised with respect to our 214 comments in the NPRM section, it relates to areas for which we seek comment on, and that's important to note. We seek comment on and we raise all types of questions as a way to elicit the maximum amount of input that we can from the public on every issue that we can possibly think of that might be of interest to someone in the community that we're seeking comments from. So just because a question is asked, it doesn't mean that that's the direction the commission necessarily is leaning in one way or the other. It is simply because we're putting that out there because we want to hear from the community, from anybody that has an interest in this, how they view that, pro or con, and we just have to frame the questions in any way that we think will at least raise that issue for them.
Yeah, again, and we can't reiterate it enough, your input is key to this process. This is a very wide-ranging item that gets into and explores a lot of different areas. Some of them are interrelated, some of them are not. And so if there are, even if you have very discrete concerns or very discrete elements of this that are of interest to your state and local governments, please participate in this proceeding, even if it is just to comment and let us know what you're thinking about a very discrete issue. We welcome that participation. That's great.
Well, our webinar has come to a close. We want to thank Adam and Terry for doing a fantastic job today. Again, folks, if you have any other questions, send to iga.gov. And obviously, IGA@fcc.gov, sorry. And we had one final question. Someone asked if the presentation today was available for download. Sometime early next week, maybe as soon as Monday, look at the IGA page at FCC under past events. Hopefully this webinar will be up. And with that, we'll wish you a good day and thank you.
We do have one more question that's come in after the final buzzer, which we'll allow since we got it. It asks, how does the NPRM and NOI apply to privately owned poles, meaning those owned by a consumer? I do not believe that the NPRM or NOI would apply to a privately owned pole. So the rules that and the questions that are asked are all being asked under the statutory umbrella of Section 224, which applies to utilities and telecommunications providers, and a privately owned pole would not fall under a utility or telecommunications provider. So to the extent a dispute arose between a broadband provider and a consumer that privately owned a pole, that would be outside of the commission's jurisdiction. So the short answer is it does not apply to privately owned poles. All right, thank you, everyone.